Hi, everyone. I'm Alex Solo. I am the co-founder of Sprintlaw. Thanks for coming along to today's webinar. We'll be talking about the new unfair contract laws. And this presentation is rather dramatically titled, "Is Your Small Business Safe?" Which sounds serious, and in fact really is quite serious. I think this is in the last sort of 6 or 7 years of the law changes that I've seen, one of the most significant changes to commercial law that affects a lot of smaller businesses. So it is something really to pay attention to and work out how it might impact your business and some of your agreements. Before we get into the kind of subject matter of the presentation, for those that don't know us, I just wanted to give a quick intro to Sprintlaw. We're an online law firm for startups and small businesses. Our business model is sort of on the screen here now. Traditional lawyers charge by the hour. One of the big points of difference in working with us is that we're fixed fee lawyers. We give you a transparent upfront quote and price for any legal services you may need. We work in pretty much every area of commercial law, from contracts, IP, employment, privacy, and so on. We also have an optional membership. You don't have to sign up, but about 90% of our customers kind of end up signing up to it. It's a really great way to build an ongoing relationship with us. You get unlimited quick consultations with lawyers whenever you have quick questions, discounts whenever you need those fixed fee services, and a few other sort of software tools and benefits as well. So for those that are not clients of ours, hopefully at the end of this presentation, you might consider becoming one, because I'm biased, but I do think we're the best lawyers that are sort of out there. And here's a little bit of a profile of our firm. We've been around for about 6 years. We have a bit over 6,000 clients, lots of awards, lots of reviews, a happy team. And Australia is our biggest sort of market that we're in, but we've recently launched in the UK and New Zealand as well. And we're recently named as the fastest growing legal business in Asia Pacific, which we're quite proud of. So what are we going to talk about today? Well, first we'll talk about unfair contract terms in general. What exactly are they? What is the definition of an unfair contract term? We'll then talk about these new laws. What are they? What's changed? And do they impact you, or who do they impact when they come into force in November? We'll then look at some case studies, and we'll be looking at, I think, 4 different types of common unfair contract terms. Cases where, we see clauses that under these unfair contract laws potentially would not be allowed or may need to change. And we'll show some examples of wording changes that might be made to bring them into the realm of potentially being fair under the new laws. And we'll sort of end with some practical steps that you can take to avoid some of the potential heavy penalties under these new laws. Now, as I'm going through, we have a Q&A function in Zoom. You can see it on your screen somewhere if you find the little Zoom panel bar. Do feel free to drop your questions in the Q&A feature as we're going through. I'll keep an eye on it and try and answer them as they come in. And if we have a little bit of time at the end, I'll leave a space as well to answer any questions I didn't get to, but do feel free to drop them in along the way. So let's chat a little bit about what are unfair contract terms. Well, unfair contract terms are an Australian law concept, in fact, and they were introduced back, I think, in 2016 under a change to the Australian consumer laws. And the idea was that it was recognized that a lot of people sign contracts really without reading them or without a chance to negotiate them, and particularly smaller businesses and consumers. And you, as a consumer, everyone would have experienced this a lot, where you're ticking a tick box terms and conditions, or you're signing up to an agreement with a lot of fine print that you don't read. And you find out later that there's a lot of hidden nasties in those agreements, things that if something goes wrong, meant that you may not actually have any recourse, and the business might say, well, you agreed to our terms, you should have read them, buyer beware, sort of thing. So the idea or the policy principle behind this regime was thinking a bit about in this modern world, particularly with the rise of digital agreements, this kind of basic principle of buyer beware may not actually be a reasonable way to run a fair and sort of stable economy. And so let's put some laws into place just for these particular type of what they call standard form agreements, where, okay, we're going to recognize the fact that a lot of people won't necessarily read the terms and conditions, won't have a chance to potentially negotiate these terms and conditions. Let's put some laws in place which prevent the use of certain nasty clauses in these agreements to protect consumers and also to protect small businesses who are very much, in many ways, kind of like consumers and may not have access to lawyers to review and negotiate every agreement that they sign. So that was the kind of policy purpose behind the regime. It was introduced with, unfortunately, not a very clear definition of what an unfair term is. It gave a qualitative definition with a few features which we have on screen now. So the first is any terms in these standard form agreements that create a significant imbalance in the parties' rights and responsibilities. So, it's really good for one party, but really bad for the other, which is often the case with some of these standard form agreements. That is a signal that it might be an unfair term. If the term is not reasonably necessary to protect the legitimate interests of the service provider or supplier who's sort of requesting the terms be signed. So obviously, in a relationship between a service provider and a customer, not everything can be 50-50. One party is, by nature of the relationship, doing more, providing a service. And if it were the case that, every business that took on clients couldn't protect themselves from liability risks and so on, and couldn't have, cancellation clauses and various other sorts of things, it would make these businesses uncommercial. So the law did recognize that the terms do potentially need to exist to legitimately protect the business that's asking them to be signed. But the question is, are we going too far here? Is this beyond what's reasonably necessary to protect their legitimate interests? So again, this quite qualitative definition of legitimate interest, but certainly trying to capture that balance there. And then finally, if relied on, would the term cause detriment to the person affected, so to the consumer? If we were to allow this potentially unfair term to be enforced, would it cause financial loss to the client or the customer? And these are the factors. If these three factors are sort of ticked or present, then a term may be considered unfair. If not, then the term's not likely to be unfair. And if there's a little bit of some of them, but not all three, it becomes that gray area where it's not clear. Now, in the regulations and also on the ACCC website, and the ACCC are the body that kind of sort of enforce and monitor the Australian consumer laws, they give a list of examples of clauses that might be unfair, and we'll go through in a bit of detail in a few slides' time some of those examples and talk about them in more detail. But they give a non-exhaustive list of potential terms that may be unfair, and so that gives you a sense of what might be considered to tick these three boxes. And that list has become known by lawyers as the grey list, because it's the grey area list of potential unfair terms. And again, I encourage people to have a look at it on the ACCC website, and it'll give you a sense of what might in practice be unfair and what might not. So again, a qualitative test, we've got some examples. The challenge with this stuff, and the challenge often with any kind of law, is that you never know for sure whether your term is unfair or not because the test is so qualitative. It would be nice if they had an exhaustive list of the 10 types of terms that you couldn't use and everything else was fine, but that's just typically not the way that the law works. And so one thing, when you're getting legal advice on this, you're going to ask a lawyer, is this unfair or not? A lawyer is going to be very reticent to say to you, that's definitely unfair or that's definitely not unfair. All we can really say is, look, based on the law, the cases that we've seen and the examples on that grey list, we think this is high risk, medium risk, low risk. And as a business who's potentially drafting one of these terms, you would make a decision as to whether you are happy with a medium risk term if you think it's quite important for your business. So that's sort of the way that we think about this stuff. So what is the new law and what's changed? Well, these unfair contract terms, as I mentioned, have been around for a little while, but the new laws that are coming into effect in November have two quite significant changes, which mean that they apply to a broader range of businesses, and the businesses that they already applied to, it's become a lot more serious to be thinking about these terms. So the first is that the scope's expanded. It applies to more businesses. And the second is that if you don't comply with the laws, there are new penalties. In fact, some of them are financial penalties, which didn't exist before. So I'll just dive into those in a little more detail. in a couple of slides. So before I get to that as well, I should say there's a threshold question. Do these changes actually impact you and your business? So who does the unfair contract laws apply to? Well, as I mentioned, these apply to standard form agreements. So if your business has a standard form agreement that your clients sign or accept, then that's kind of the first criteria for whether these laws apply. And what is a standard form agreement? It's an agreement that is used again and again by your business. There's little opportunity for your clients to negotiate it. Even if you give them a few options, you've got 3 or 4 different packages. Particularly the new laws clarify that can still be standard form. It's distinct from an agreement that you might negotiate and sign, and you might have the opportunity for each client or each customer that you work with to really change the legal terms of the agreement. But if it is a set of sort of fine print that's presented, attached to your invoices, accepted, with very little negotiation by most of your clients, and not presented in a way where, let's discuss this, but more presented in a way of, these are my terms, sort of take it or leave it. That's what the definition of a kind of standard form agreement is. So if you have one of those, then you're kind of in the domain of these unfair contract terms. The second criteria is, who are your customers? Are your customers what the law defines as a consumer or small business? And the scope of the second part, small business, has just been expanded under the new laws. So if you're only dealing with very large enterprises and that's all you deal with is your customers, well, these laws are not designed to protect them. They're savvy enough, sophisticated to have legal advice and to kind of know what they're signing. But if they're being signed by consumers, or what the law defines as a small business, that's the second criteria. And the third criteria is, are you going to use these after the law comes into force on 9 November 2023? Now, it's important to mention that for agreements that have been signed prior to 9 November 2023, they're not captured by these new laws. But if they renew after 9 November 2023, then that renewal will be captured by these new laws. So if you have existing clients on retainers and those sorts of things, when the retainer renews, you work with them under the terms after 9 November 2023, these laws will apply. So it would be the case that you would want to update existing ongoing agreements, but you don't have to worry about agreements that you signed and sort of closed off prior to 2023. So it's something that applies sort of moving forward. So let's dive into the specific changes and what they mean. So the first is this wider scope aspect. Previously, the laws applied if one party had 20 or fewer employees, or the upfront price payable is under 300,000 or under 1 million for contracts lasting more than 12 months. Sort of designed as per the first bullet for sort of really small businesses. And the second bullet point is actually quite broad and did capture a lot more of other small businesses, although it was always worded in a fairly confusing way because the way that price has been structured in various types of agreements may not fit that criteria very clearly, given many different kinds of billing models. It's become a lot simpler in the new scope. There's 2 bullets. If either of these 2, you don't need both of these 2 to be satisfied. If either of these 2 is satisfied, then it's going to fall within the scope of being what's called a small business contract. If a party has 100 or fewer employees or makes under 10 million in annual turnover, they'll be considered a small business party for the purpose of the unfair contract terms laws. So just coming back to this slide, we're talking about this criteria here and the small business segment. This is the definition of a small business. They have under 100 employees or make under 10 mil in annual turnover. And a consumer, of course, is just a consumer, so an individual who may not even have a business. Both of those categories are captured by these unfair contract terms laws. And it should further be clarified that the laws actually apply if a party ticks either of this criteria. So if your business ticks this criteria, then it will apply to all of your agreements, irrespective of if the other party is larger or smaller. It really does apply to a broad range of commercial agreements. Seen a few questions here. I might deal with a couple of them at the end because they're a bit more sophisticated, but Linda's asked, if it's a client that buys from you monthly under existing T's and C's, does the new order after the changes in November mean the current T and C agreement needs to be updated, or just for brand new clients? So the answer to that, to some extent, depends on the way your T's and C's are drafted, but highly likely that yes, if a new order is made after November, even if it's under T's and C's signed before November, typically the way the law looks at that kind of order form and standard T's and C's structure is that every time an order is made, a kind of new contract is being made in a legal sense. So yes, you would want to update those T's and C's even with your existing clients if you know they're going to make orders after the changes in November. That's the answer to that question. Again, unless you have some kind of complex wording in the terms, but I'd say it's highly likely you would. So guys asked, does it apply to one-off transactions, for examples, repairs and consultations? Yes, they do apply to one-off transactions. The main criteria is not that it's an ongoing arrangement. We will be talking a bit about termination clauses and automatic renewal clauses in the examples I'm going through. And so that gives you the sense that we're talking about ongoing agreements, but that is by no means a criteria. The criteria is just that there are standard form agreements. If you go to a mechanic and they make you sign a one-pager along with your invoice and they just do one fix for your car, doesn't matter that it was a one-off service. The fact that you were presented with potentially standard form terms and conditions, would be enough for it to be captured by the Australian consumer laws. And then we have another question. Where or when does the contract begin? At the marketing of the service or at the signing of the contract? It kind of depends again on the way that your product works. Some people don't actually have a moment where contracts are signed. There's a tick box acceptance, or acceptance can occur by conduct where someone starts working with you. But in most cases, if there is a contract that is signed or agreed to that kicks off a service, that would typically be when the contract begins. And normally there'd be a start date, and you refer to that as the acceptance. So if you start marketing a service and promoting it on a certain day, but a customer only signs up for the service, a month later, let's say that's on 1 December, then from a legal perspective, the agreement would commence on 1 December. Okay, I might come back to a couple of those questions and just keep moving through. We talked a little bit about the wider scope of the new laws. They're applying to more small businesses. The next thing we're going to talk a little bit about is the penalties. And this is quite significant because, as I mentioned, these laws themselves around unfair contract terms are not new. They've been around for a little while. But previously, if you had one in your agreement, it wasn't that you could get fined a large amount of money. All that would happen is if one of your terms was found to be unfair, it would be what in legal terms we call void. It would kind of just be crossed out of the agreement. The rest of the contract would still operate, but there weren't clear sort of large financial penalties just for having an unfair contract term in the agreement. And this led to a practice where a lot of law firms who were drafting people's customer agreements, and sort of we're included in this category, we would advise clients on unfair contract terms, but provided the contract was structured in a certain way, it might be that we didn't require clients to or we didn't notify clients to be incredibly worried about the inclusion or potential classification of a term as unfair, because in many cases, sort of worst case scenario, the term would just be crossed out. But if there was another clause that still protected the client, well, it would still apply. So the fact that there weren't financial penalties was quite significant in the way that this was leading to sort of contract drafting practice. But one of the reasons for these new laws is, in a sense, and this is kind of mentioned in some of the policy documentation, realizing that without financial penalties, the law had kind of failed to change the small business contract practice. People had just added in a few cute words into their contracts, but really they were doing very similar contracts to what they were doing prior to the introduction of the laws. So it was recommended, and it's now been passed into law, that look, it's not just that the term will be crossed out and that's kind of it. In fact, in addition to that, and that can still happen, the clause can be crossed out, the entire agreement can be voided or refused to be enforced, and penalties financial penalties up to a maximum of 50 million for businesses and up to 2.5 million for individuals can be issued for businesses that are using these terms in their agreements. And furthermore, the penalty and the way that it works is actually calculated for the number of times that term has been agreed. So, for example, if you've got 50 clients who accepted your standard T's and C's, and there's found to be an unfair term in there, you could be penalized times 50 for each instance that the unfair term was signed. So, really, if you're using these terms a lot, there are incredibly large financial penalties. And it's certainly something to be worried about. Now, if you're a small business, it's unlikely that if you're found to be breaching the unfair contract laws and it ends up in court and it ends up with a judgment against you, or the ACCC decides to issue a fine, that you're going to receive the maximum penalty of squillions of dollars. But certainly they can issue serious penalties, and there's not really a cap on what can be issued. It's not at all like a parking ticket. It really can be very significant, and there is lots of talk of wanting to deter these unfair contract practices. So this is why it's quite, I think, important for you to look at your terms, even if they were drafted by lawyers, even if you have thought about these issues before. It's an important time to really revisit those agreements, have a look at them again, and make sure that you're doing what you can to reduce the risk of there being unfair terms, given that there's potential financial penalties now. So we're about to dive into a few case studies. I've noticed a couple of other questions come through, so I'll attempt to answer some of them. Basim has asked, what if your company is a SaaS that only receives commission for providing web marketplace platform services? Do these laws apply to you? Look, I think they could. They probably would. I would probably need to know a little bit more about, I assume that's kind of your business or a model that you're involved in. I need to know a little bit more about the model, but in short, if that SaaS company has a standard form agreement that either the customers or the other side of the marketplace agrees to, maybe both, if it's a standard form agreement, terms and conditions of some sort that people are accepting without the ability to negotiate, if they're small businesses or consumers, and you're using this after the date of November, yes, those terms would be captured by the unfair contracts laws. And again, if there's terms in those terms and conditions that breach these laws, you could potentially be issued these fines and penalties. Another question, how does this effect apply to a direct-to-consumer product-based business e-commerce? Very, very common for e-commerce businesses to have standard terms and conditions. It's typical that at checkout, people will agree to terms and conditions of delivery. A consumer will order services or products online, and those terms and conditions, again, are going to fall within the scope if there's consumers being sold to of these laws, assuming that they're standard terms and conditions that aren't negotiated, et cetera, et cetera. So yes, similar answer to the SaaS one. If there's standard terms that are being accepted with like a tick box acceptance, these laws are going to apply. And you can sort of see from the tenor of my answers that this really does apply to, like I said, the vast majority of business agreements. And that's why a lot of lawyers are now talking about it and trying to spread awareness about it. Pretty much every e-commerce business that sort of sells that way needs to have their T's and C's ideally reviewed and checked to make sure that they're not breaching these laws. Is there an insurance product that could be purchasing that the dollar penalties are substantial? It's an interesting question. I'm not an insurance expert. There are a few insurance partners we have that I could introduce anyone interested in and answer that question to, who may be able to answer it. Potentially there are often sort of professional indemnity insurance claims, and some of them protect you from regulatory liability. I'm not sure how the insurance companies are dealing with this new law and whether there's specific insurances for it. So something to check with your insurer. If you don't have one, do reach out to us and we can connect you with some of our partners. Is there a link to the ACCC to see what the grey examples are? There is. We can probably circulate that afterwards for those that can't find it online. It's called the grey list. If you Google it, you should be able to find it fairly easily. Lots of questions, which I love. I might pause and continue going through some of the case studies just to make sure we're getting through the content, and then come back to some of these towards the end. So case studies, UCTs in practice. I'm going to go through a few different examples of different types of unfair contract terms and clauses that you might have seen in your agreements, and suggestions for how those agreements could and should be changed, for better compliance with the unfair contract terms laws. These examples are going to go through some of the items that are on that kind of gray list of examples applied to specific cases. Since the laws came out, there's not a ton of court judgments that we can actually look at that tell us whether a particular set of words is an unfair contract term in a court's opinion. But there have been a few, and I've put a few case references on screen for those who are particularly interested in reading a bit more about some examples that might resonate with their business. So the first one is this kind of unilateral fee variation clause. So let's imagine a software licensing contract that allows the software provider to increase the licensing fees without prior notice and without offering the customer the option to terminate the agreement. So this is quite common in software agreements where, in the fine print of the T's and C's that you accept when you're signing up to a software platform, it says, oh yeah, this is the price, but we may increase the fees at our absolute discretion. That's just part of the model. They may increase from time to time, and we'll charge you more if that happens. You'd see these very simple clauses, which you have on the left. We reserve the right to change the fees for time. We'll notify you in advance if we do this. That one at least has a little bit of a notification requirement, but it has this just right for one party to change the fees with no clear obligations or reasonableness requirements to allow the customer to kind of get out of it, and no time period for notice. You could notify them the day before. You can see how this term might be seen to be sort of unfair. And there's an example, ACCC versus Serve Corp. It's not a software licensing agreement. It's a sort of rental leasing type agreement, but very similar concept where there were unilateral rights to increase fees, and there weren't clear notification requirements or rights for the agreement for the client to sort of terminate the agreement, and people found themselves locked into these sort of difficult to get out of rental and leasing arrangements where it's difficult for them to move at short notice. So they ended up just having to accept these increases in fees, and again, it became sort of unreasonable, led to some complaints, and ultimately ended up in court. And those terms were deemed to be unfair terms because of these sort of issues. So a potential new clause, obviously you may, as a software business, you want to be able to change your fees. You may need to for your business model, for inflation, for many other reasons. So a potential new clause which would have a lower risk of being an unfair term is one where you're giving reasonable written notice and ideally specifying a time period in the terms, allowing people to terminate immediately, really with no penalty or fee if they reply to your written notice. And then you can probably say afterwards, if you continue using it, then you'll be taken to have accepted it. But of course, even that last sentence, if you wanted to be extra careful, you could require some kind of affirmative action to reconsent for the change in fee price. Maybe the next time they log in, there's a notification that says, hey, the fees have increased, and potentially you provide a grace period or something like for them to get out of the fee variation. So this is the flavor of changes, and you can see from a customer or client's perspective, making changes like that can have sort of a really beneficial impact for the customers and clients. And this is really what the law is sort of trying to get to in the way that we deal with these kind of fee variation concepts. Moving on to case study 2, we've got an example of a landscaping contract that allows the landscaper to avoid liability for any damage to the client's property due to their own negligence. So this is all about liability. And again, on that gray list, there's some reference to very one-sided liability provisions. I got a case reference there of a couple of examples where basically the business just said we're not liable for anything, or we're only liable in very limited circumstances. And this is quite common, a quite common trick that lawyers would sort of do when they were drafting standard terms for service providers or clients. They would just have a liability clause that says, look, we're not going to be liable if anything goes wrong. Like, yes, you've made an order through our platform, but if anything goes wrong whatsoever, too bad, which kind of undermines the whole point of the agreement. It makes it seem like there is a real agreement, but if you wanted to ever sue the vendor under the agreement, well, they're not going to be liable anyway. So sort of what was the point of the terms? And one of the first principles I learned when I was sort of training to be a lawyer, a commercial contract lawyer, was, the first clause you want to look at in any contract when you're reviewing it is the liability clause, and the second clause is the termination clause. Because those two clauses in any agreement really give you a sense of, we're going to look at all these other terms, we're going to look at what's fair, we're going to look at what's reasonable, but if something goes wrong, what can our client actually do? What recourse will they actually have? Is there any liability that they can actually put onto the other party? And so what are the stakes that we're dealing with here? And finally, if they want to get out of this agreement, how can they get out of it? So again, oftentimes when you would know that the other party isn't going to read the sort of agreement, you'd put these complexly worded liability clauses, which no one understands, but actually mean the service provider will have no liability. And you can see on the left here, we have an example of one of these clauses. Any damage caused to the client's property, whether by act or omission of the landscaper, will not result in any liability on the part of the landscaper. The client fully assumes all risk of damage and loss related to the landscaping services provided. So again, it's like a buyer beware concept. I'm going to do some landscaping for you, but if it's bad, too bad. You cannot sue me is what that clause is trying to say. Very high chance that a clause like that would be deemed to be an unfair term. On the right, we have a much fairer clause. Landscaper will take all necessary precautions to prevent damage to the client's property. Should any damage arise as a result of the landscaper's negligence, the landscaper will be responsible for rectifying such damage at their own expense up to a maximum liability amount of, and here we have a dollar figure, AUD $5,000. Now, that dollar figure, $5,000, may actually still be unfair depending on the value of the landscaper's contract. If the landscaper got paid $200,000 and their maximum liability was $500,000, then that actually could be an unfair term. But if they're getting paid a couple of $1,000s and the liability amount that they've limited to is somewhat proportionate to the amount that they've received, then at least in my view, that would probably be a liability limitation that was reasonably necessary to protect the legitimate interests of the landscaper. The landscaper is only getting paid $2,000. He can't be, or she can't be in a position where they're getting potential liability for $1 million or $2 million, for a small $2,000 job. But equally, if it's $0, it's like, well, the landscaper can cause a lot of loss and damages and have no potential liability for it. So it's very much about balancing what's reasonable with protecting the interests of the service provider. And so this is the kind of clause that you might see instead, rather than a blanket liability limitation. Moving on to case study number 3, we've got termination. So this is an example of a catering services contract that imposes fines on clients for canceling their catering services before the contract term ends, while permitting the caterer to terminate the contract at their discretion without incurring any penalties. So this is, again, featured on the grey list, and the concept is, one party can get out of it. The caterer goes, oh, I've got better orders than you. I'm canceling. Sorry about your event. But the client wants to cancel. The catering provider says, well, if you cancel, there's going to be, XYZ cancellation fee. And you can see on the left, we have past clause. If the client cancels the catering services prior to the end of the contract, a fee equivalent to half of the total contract value will be imposed. The caterer reserves the right to terminate at any time for any reason without any obligation or penalty. Great for the caterer. The caterer loves that. The client, not so much. It's not very fair. And again, highly likely a clause like that would now be seen to be unfair under the unfair contract terms regime. A potential change that could be made to the clause: if the client wishes to cancel the catering services prior to the end of the term, a cancellation fee will be imposed as follows. X% if it's more than Y days, Z% if it's more than Y days. What we can do with these kind of bullets is we still potentially want there to be a cancellation fee. We're not saying that the caterer can't charge a cancellation fee. It's very inconvenient for a caterer if they've prepared all of the goods and products and services and time for this service and it gets cancelled. It's reasonable to protect their legitimate interests that they may want to charge a cancellation fee. But a flat 50%, even if it gets cancelled, let's say 1 day after it was booked, isn't reasonable. Probably doesn't reflect the losses that they've suffered by the cancellation. So having some kind of, if it's less than 5 days or 3 days, then we'll charge you more. If you give us more notice, we'll charge you less of a cancellation fee. That's much more likely to make the clause be seen as reasonable. And again, we have something reasonable the other way around. If the caterer seeks to terminate the contract without valid reasons, for example, some force majeure, out of their control event, or maybe the client doesn't pay, the caterer will refund any prepaid amounts, and maybe subject themselves to a reasonable termination fee to be agreed upon by both parties. So again, it gives the client some recourse if the caterer leaves them high and dry. So you can see the clause on the right, much more reasonable, and the risk of it being unfair much lower than the type of clause on the left. Finally, just moving into our last case study, we're going to talk a little bit about auto renewals. So these are clauses that many people would have encountered. You sign up for something and then you find out that you're being rebilled for it without getting notified and without really consenting to it, and making it quite difficult for them to actually get out of the agreement. So we've got an example on screen of a gym membership agreement that automatically renews at the end of the initial term without obtaining explicit consent from the member, and then making it difficult for them to cancel. And there was quite a significant case, ACCC versus Crisco Hampers Australia, which went into quite a lot of detail about the auto renewal concept and what might be considered unfair in this scenario. And this was a hamper product where you could choose to pay for Christmas hampers in installments. So you could buy your hamper up front, but if you wanted to pay for it in installments, without quite realizing it, when you paid in installments, you're actually signing up for a subscription for your next year's hamper and the year after that's hamper. And so even after you'd paid off the hamper, you'd find yourself still getting deducted monthly fees. And that was considered by the ACCC to be unfair for several reasons. One is it was a little bit non-transparent. Customers were likely to be confused, thinking they were paying something off in installments and finding themselves on a subscription. So there's a transparency issue there. And also, even though it did allow them to cancel and get a refund, that process was a little bit complex. One of the interesting points that was raised in the judgment was that when the refund was actually given in that case, while they were happy to refund people that complained, and they'd get back their difference, if it had been a year or two, there was no financial compensation or interest payable back by the hamper company to the client. So the judge was sort of suggesting that if you want to do this, we'll refund you thing, and a time period has elapsed, it's not enough to just give them their money back. They've lost potential interest. So you should pay them some interest to make up for their losses, which is quite a novel concept and not one I've really seen drafted after that case, but certainly it's spelling out how people are starting to look at these automatic renewal clauses. And for anyone that has auto renewal, it means that you want to actually start thinking about how you run this process in a little more detail. So a pass clause we have on the left: at the conclusion of the initial membership term, this agreement will automatically renew for successive periods equal to the initial term, and the member will continue to be billed at the current rate unless they provide written notice of non-renewal within 5 days of the end of the current term. So this is a very, very common automatic renewal term. It's in a lot of agreements. It's certainly common in gym agreements and software agreements, and other sorts of member or subscription agreements. And so I expect a lot of businesses that operate on these kind of renewal or subscription models to have something kind of like this, maybe not quite this harsh, but something a little bit like this. And therefore, you want to be looking at these. On the right, we have a potential new clause. Again, we're not saying we need to get rid of automatic renewals, and nothing in this judgment suggested that automatic renewals would never be okay. If you've got a model that relies on automatic renewals, It's not at least my view that you need to get rid of that concept to be compliant with the laws, but you need to provide some more reasonable provisions around how the automatic renewal works. So on the clause on the right, we have the concept of a grace period. So yes, it will automatically renew. However, you've got 30 days after it renews to cancel it, and we'll give you a full refund. There's clear instructions about how to get the refund and clear timing of when the refund will come in. We've also got a clear reminder notification at least 30 days prior to the end of the term, informing the member of the automatic renewal and their rights regarding the grace period. So again, still there's a little bit of risk in any kind of automatic renewal. And it may come down to how transparent this clause is, how it's communicated to your clients, and sort of how you, if you still trick them into being on automatic renewals, then even all this stuff may still put you in the camp of being sort of a supplier of unfair terms. But these kinds of things, grace periods, notifications, clear places for them to contact you about it really go a long way in terms of reducing the risk, particularly if you read the issues that were raised in this judgment and a couple of others. We got a little bit of a summary of how to avoid penalties. Before I go through this, we've got a little bit of a backlog of questions that I might just deal with in the Q&A. Start from the bottom. We've got one from Linda. Do the new laws apply to T's and C's with international client suppliers, e.g. in Italy, Poland, US? Interesting question. Yes, they would if those clients, if the business is being conducted sort of in Australia. If it's a completely international agreement, potentially not. There's some laws about what's considered for business to be being conducted in Australia. And probably to give you a specific answer on a specific scenario, we'd need to look at the situation and sort of give you some advice on it. But there's nothing in the laws that suggests that both parties need to be Australian only incorporated businesses. So if there's an international client or supplier who's supplying to you in Australia, they actually may need to comply with the laws in their agreements with you, at least in relation to their Australian clients, and potentially sort of vice versa. We got one, unfair terms in employment also. Does it come under this? In public liability, professional indemnity, is there any particular insurance clause we should look into? Interesting. In employment law, there's already a bunch of workplace laws that cover the concept of unfair terms in employment agreements. And if you are complying with existing employment laws, there's a decent chance you've probably covered a lot of the risks around unfair contract terms. I believe it is the case, but I'm not 100% sure that the unfair terms would also apply to employment agreements. It's not something that comes up all that much because the employment laws have done some of the work in preventing employees from signing some of these terms. It might be a point that we need to get back to you on because I'm not sure if there's a specific exception in the laws or not, but it's certainly not something that comes up all that much. It's really the commercial contracts that we're talking about a lot of the time when we're dealing with these unfair contract terms laws. We've got another question. How do you see these laws interacting with things like employment or contract agreements? So I gave my answer on employment already. As I said, there's a suite of regulations and laws that kind of deal with this. So I'd focus on complying with those, and you're likely to be compliant with this for employment. For contractor agreements, though, those are not as well covered by the sort of workplace law regime we have in Australia. So contractor agreements are certainly covered by these, and there are lots of work that we do now and we'll be doing in the future around standard form contract agreements, whether you are a contractor or you're signing up a contractor. Either way, if there's a set of standard terms that are used en masse, these laws will certainly apply to those. And so again, this may affect the liability agreements, the payment terms, and termination terms, those sorts of things in those standard contractor agreements. How would these apply to marketing of travel services, i.e. cold calling clients or social media marketing a cruise, selling the cruise in principle, and then forwarding the contract for formal signing and implementation? There's two sets of laws that apply. There's a bunch of direct marketing laws also regulated by the ACCC around cold calling, cooling off periods, and those sorts of things. And there's the do not call register. So there's a bunch of legal considerations separate from this that apply to that form of business. Social media marketing is a bit different to cold calling. It has less regulations of that kind, but it has its own other sorts of misleading and deceptive conduct regulations. So a whole host of laws already there to think about in the way that your process is set up for those businesses. But in relation to the unfair contract laws, at the end of your question, you talk about there'll be a forwarding of the contract for formal signing and implementation. So that act of forwarding the contract, assuming it's a standard form agreement, you know, the client or the customer doesn't have an ability to negotiate it, even if it's like electronically signed or physically signed. If it's not presented in a way that, you know, this is an agreement, let us know if you have questions or you want to discuss, but it's more presented as, and here are our terms and conditions, please accept them, and then we'll continue, which often I would imagine those sort of things are, then yes, those terms are captured by the unfair contract laws because they'd be standard form kind of agreements. We have Neeraj has asked for a link to the ACCC. Maybe one of our team members can just drop a hyperlink to the ACCC website in answer to that question. Justin, thinking about the financial implications, should these changes discourage people from being a low-income sole trader, or just help people to get more savvy about operating a business? I think the latter. I don't think there is anything in the way that this policy has been designed where they're wanting to make it tougher to do business. There's certainly a change cost for people that have been operating businesses with standard form contracts before, you know, this change comes into effect and afterwards. It may be a little annoying to change your processes, to actually have to pay, you know, lawyers to update your terms and those sorts of things, and to understand this a little better. So there's certainly a change cost, but I think really some businesses and some of our clients who really had more of like a principle of having fair terms in the way they did business aren't, and like I said, there's a percentage of people that they fall under the unfair contract laws, but their agreements actually aren't too bad, and they may not need to make many changes because they already were giving people notices of automatic renewals, giving them fair termination rights and reasonable liability positions. So I think what they're trying to do with the regulations is really just ensure that fairer business goes on, that when we're using these standard terms, we're not using it to sort of pull one over the clients or customers, but the terms are a little more fair and to promote fairer business. And I think, again, you can be a low-income sole trader, a micro business, whatever it is. All we're saying with these laws is just make sure your contracts are reasonable. You're still allowed to protect your liability, as I've kind of made the point in some of my examples. It's not the case you now have to be liable up to $1 million. You can still get insurance. You can still limit it if it's reasonable. It's just about not being unreasonable. So that's, I guess, my view on that question. Do these provisions apply for T's and C's for a zero-cost service? Yes, they would. Again, depends on the context of like what's being provided, how it's being provided, and the nature of what the zero-cost service is, and whether it's truly zero cost or it's a discount or for something else. If you could show that the zero-cost service was really just a nice free thing that was being done by the supplier, then the unfair terms would be nicer to you. You could probably have a much greater limitation of liability because you'd say, we're not making any money from this, so we can't take any risk. That would be a reasonable argument to have stronger liability terms. So the way they apply might be different if it's a zero-cost service, but there's nothing to suggest that that alone would mean that it doesn't sort of apply. Lots of great questions here. Adrian, we have a service agreement which is ongoing per each financial year and applies to our jobs that year. Should I move to have the agreement each time we do a job? A whole lot more admin. Obviously, I'd do an update after November. No, I don't think you need to change the process or procedure. Again, I'm trying to give you helpful answers without knowing the full context of your business. But based on what you've written there, I don't think you would necessarily need to change, your structure of how the agreements are done. I just think, yes, you're going to have to do, if things are happening after November, you're going to just have to do potentially a once-off update to those kind of standard agreements to make sure that the terms are fair. And then if that structure is working for you, there's nothing really in the laws that means you have to change it. It just means that the fine print of the agreement, again, if it's a standard form, just might need to change in a few places. Does providing a service on a best efforts basis break the law? It is not always possible to fix the issue the client needs. Yes, that's fine. Again, I think it depends on the circumstances. Like if you're providing, we have a lot of clients that deliver, for example, SEO services, and they're for those that know what that is in marketing, that's an example where you're trying to improve a client's website and help them publish articles to improve their ranking on Google search when people search for their business or potentially their products or services. So that's a really great example where like the business will do all it can, but it can't promise you that Google's going to love what they do. So it's difficult for them to promise that a particular result. And again, if Google's algorithm changes, it might break the customer's rankings, and there's not much that the service provider or supplier can do. So typically, we write a lot of best effort type disclaimers for those kinds of agreements. For that kind of business, it's quite reasonable to be saying the nature of our service is a best effort service. We can't guarantee that we'll be able to deliver results or fix any problems that may emerge. So I think that's fine. Other types of services where the customer might really think they're getting the deliverable, but it's and all they're promised is a best effort to receive the deliverable, or they're expecting things to be repaired, and you should reasonably, if you're a professional of whatever the service is, be able to repair it. Saying these best efforts type things could become an issue. Again, if you need to say best effort, you can always offer a refund. If we can't fix it, we'll give you a refund. So there's ways around it. So best efforts by itself is not necessarily an issue, but may require these additional kinds of considerations that I'm mentioning. We got a longer question, I think, from early on. I haven't answered yet. We're a non-small business, but we hire subcontractors, small businesses. The main contractor's contract to us is unilateral, but we hire small business subcontractors, so we are squeezed in the middle. What should we do in our main contracts to make them back-to-back to main contractor? That's a bit of a specific question. I don't really want to provide an answer without probably getting a bit more information about the situation. So yeah, I'd encourage you to kind of contact us. But I think if there's a unilateral agreement in there that you're signing, and with the main contractor, and neither of you are small businesses, but you are the ones hiring the kind of small businesses, it's possible that, yes, that your top level contract is not covered by the unfair contract laws, but your subcontract is covered by the contract laws. So, if you could go back to the main contractor and tell them that your legal landscape's changed, it may be an opportunity to renegotiate your top level agreement. And then again, I think you kind of have to make sure that your subcontract agreements are reasonable and compliant with these laws. But again, if you want further advice on that, I'd encourage you to sort of reach out. I think that's most of the answer. There was a question, can we provide members with a simple blurb to send to customers to help give them a heads up on why they'll be getting some new T's and C's and why it's happening? Potentially we could do that. I think the notification would be very different for different types of businesses, but if it's something you're interested in getting, maybe if you're a member, try booking in a member call with one of our team. And if it's a quick blurb, and you can tell them exactly what you're after, our lawyers may be able to just whip something up for you that does the trick. Okay, well, just wrapping up, what are some practical steps that you can take to avoid these penalties, avoid these issues? I think I've spoken a lot about the fine print of your agreement. Hopefully a message that people take away if they think they may have unfair terms in their agreement is to get their agreement reviewed by a lawyer. If you're not sure, we've got these free spot checks I mentioned. Take advantage of them. If you're getting quick, we'll have a quick look and we'll just tell you if there's an issue. We won't do a full review and fix because that could be quite a bit of work, but we'll at least tell you what sections of the agreement may be potentially unfair. But if you haven't had them checked, definitely get them checked. And as you can see, it's actually not super straightforward to fix them. So it is probably an area where it's worth investing in legal advice. Set up your customer due diligence process. Just make sure you're thinking a little bit about how your processes work with your customers. And is it the case that the way that you're actually presenting your terms to your customers, the way that the T's and C's are sent to them and presented and described, are reasonable, transparent, and fair, because it's not just about the fine print. It's also about the way that you present the terms and conditions for the purposes of ensuring that you're compliant with those unfair contracts laws. Think about setting up a contract compliance process. If there are tons of agreements that you've issued in the past, some of which may be renewing, think about making sure that you're getting them checked. I think it's a good idea for any frequently used agreements in your business to be reviewed and checked for compliance with laws sort of once a year. Again, depending on your business, you might want it more frequently than that. But if you've had your agreements not checked in several years, in addition to these law changes, there may be other law changes. For example, the privacy laws change at the beginning of this year, which may need to be reflected in your agreements. And just because you haven't heard any issues about it yet doesn't mean that you won't. All it takes is kind of one angry customer or one issue with the client for some of these underlying issues to emerge and cause your business problems. So think about setting that up. And finally, for businesses with employees, I think it is worth getting people aware of these unfair contract laws. Certainly, if they get questions about how cancellations, renewals work, particularly like sales teams, you don't want them to be presenting terms in a misleading way. Your T's and C's and the way they're described need to really be reasonable, or you sort of run the risk of breaching these unfair contract laws. So those are some practical steps. A great place to start is obviously getting a little bit of legal advice. That's it from me. I hope everyone found this a useful and informative presentation. We'll be running more webinars like these probably monthly for the foreseeable future. So if you've enjoyed this, please do stay subscribed and come along to our next one. But that's it from me. Thanks everyone so much for your time.